the decision reinforces, obviously, the rights of employees to privacy in the workplace, particularly in the public sector where we can get into the Section 8 analysis. But I think that the analysis with respect to the existence of a reasonable expectation of privacy has application beyond the public sector as well. And very importantly, the expectation can extend to technology supplied by the employer, which is not always the case. And employers should proceed with some caution, I think, when they're conducting any kind of an investigation that involves information that's discovered by accident or happenstance, which could include some personal information. And once you've sort of accessed personal information, then there's no going back. The horse is out of the stable, so to speak, and the damage has been done. As many of you know, lawyers are often retained to perform workplace investigations and then prepare and submit a report of their findings to the entity that retained them. That's one of the, I've done this many times. It's one of the things that I do in my own practice. And the question that sometimes arises is that report subject to disclosure if somebody who's involved makes a request for access under applicable information legislation. So if you're in the public sector, it's possible somebody might make an access request under FOIP. If you're in the private sector here in Alberta, somebody might make a privacy access request under the Personal Information Protection Act. So what are the takeaways here? Well, I think it's key that if your organization retains a lawyer to conduct a workplace investigation, it can't assume, as I just said a moment ago, that solicitor-client privilege is going to attach to that written report. And the question is one that's dependent upon the facts of the case. Importantly, the case demonstrates that just having someone make findings of fact and recommendations with respect to breaches of policy is not going to be enough to establish solicitor-client privilege. What's required is actual legal advice from the investigating lawyer to the organization or to its counsel, if the mandate has been framed appropriately, or something about the circumstances being investigated that requires a lawyer's special expertise. What is the effect of that ruling? Well, I think the trilogy, taken as a whole, really limits the scope of intrusion upon seclusion. And it says, in effect, that you can't use it as against an entity that has had its information hacked. Now, I would suggest that intrusion upon seclusion would still be available if the hacker was someone internal to the organization. So if the organization that's hacked is hacked at the hands of one of its own employees, then I think it's likely the case that intrusion upon seclusion could still be relied upon pursuant to the doctrine of vicarious liability, because of course the company would be potentially liable for the acts of its employees. So in a scenario where the hacker is internal, then intrusion upon seclusion might still apply. Where the hacker is external, is a third party, then I think the Ontario Court of Appeal has sort of put to bed the notion that intrusion upon seclusion can be relied upon.